Okay, well, welcome everyone to our CodeX group meeting. Hello, come on in. We have with us here today Nick Brestoff, the founder and CEO of Introspection, and he will be telling us all about deep learning and sort of avoiding.
I don't think anybody has any sound.
Oh, you have no sound? Monica, are you there? Okay, give us a second.
Yeah, we're sending sound out.
To others also not. Can anyone hear me? You have to unmute yourself so that we can hear you.
They're saying they have sound now.
Okay, you have.
Chat.
Oh, okay.
I think so, folks. We do mute the mic in the room before the meeting starts, so that you don't pick up the chatter here, and then we unmute it when the meeting starts.
Okay, because we're all talking about Monica, and we don't want her to.
That's exactly right.
All right. So okay. Well, let's continue. So so Nick will be telling us about how deep learning can help us avoid litigation risk. Before we turn it over to Nick, I wanted to see if anyone had any updates or news to report, other than the news that Ravel was acquired by Lexis today, which I think is big news for our community. Congratulations to everyone who was involved in that. And I already said we should introduce some kind of a acquisition tax at CodeX. You know, for anyone who's related to CodeX and gets acquired, we'll have anyone who presents at CodeX will have to pay an acquisition tax when they get acquired.
Okay, fine. I'm leaving now.
It'd be reasonable. But just friends and family shares welcome. But does anyone have any updates for the group? Any news to report? No? Do you still hear us? All right. If there are no news to report, then I will turn it over to Nick.
Okay. Thank you very much. I'm going to cover two topics. One is going to bleed into the other. The first thing I wanted to do was talk about Pacer, because Pacer is a source for.
Should I share screen?
No, he's sharing his screen.
Are you sharing your screen?
Yeah.
Okay.
Yeah,
people can see it.
That's my screen.
Okay.
I can see it. Yeah.
All right.
Okay, so
go ahead.
I'm gonna take you through in a screenshot tutorial Pacer, because we use Pacer in our deep learning system, but it has more functionality than lawyers are used to. So let me just say that the way to sort of start is where defense lawyers probably never see a civil cover sheet. It's filed when a complaint is filed, but it's very helpful for us because in the deep learning world, what you need is labeled examples, and you can combine those two things to train a deep learning model. Well, for the nature of suit code, which I've circled there, the instruction is to place an X in one box only. Even though Pacer is something of a legacy system, when it was set up, the federal judiciary thought of these categories for statistical purposes. And so every time a lawsuit is filed, one of these documents has to be filed with it, and it will get kicked out if it's not. But it's not even worth getting a document number. The complaint is always document 1, unless it's was filed in state court first. And usually the civil cover sheet is 1-1. And typically, the lawyers do have to sign off on it, but they never think about it again after that because it's understood to be for statistical purposes only. It has no other role in the lawsuit. But the instruction is basically check one box only, which means even if you have more than one claim, you have to pick the one that best describes the lawsuit. So that's sort of a beginning. And for our purposes, at least to give deep learning an early start, you can see that under civil rights for employment, that nature of suit code is 442. And so you can start to think about code numbers, NOS code numbers, nature of suit code numbers, and what they're related to. In this case, employment, or sometimes they use jobs. But now let's go into Pacer. This is sort of the top of this Pacer screen. And you can see on the bottom right where it says who can access Pacer. And now you can see the bottom of the screen, and on the top right, you can see how do I access Pacer, and then the rest of what it is. I just want you to remember that we're going to come back to something that's pretty faint on the screen, but at the bottom right, it says search this site, and basically it's a local search box. But where people go to actually search in Pacer is Search Now, and typically lawyers don't search in Pacer unless they're trying to look up something in their specific case. And to me, that was sort of a light bulb that went on. Once the complaint is filed, you get this giant silo of everything that's filed in that case by the plaintiff, defendant, or by the court. But nobody looks horizontally, and that's what I'm going to show you how to do. Of course, you'd have to have a login and password. And then the thing to do is notice that there are several tabs across the top. The only one I usually use is Civil, which is in the middle. And then I circled Advanced Search because that does not mean we are in Advanced Search, even though that's what shows up. You're supposed to click on that to get Advanced Search. So when you click on Advanced Search, you get more functionality, namely the date filed and date closed range. You can put in a start number, a start date, and an end date for your search under date filed or date closed. I almost never use date closed. I use date filed. But if you see basic search, you're in the right place. So there's an example of how the format Pacer uses 01/01 2013 and then 1231 would get you a whole year, but you can ask for a week if you want to. And then the next thing to do is go down and look at a party name. I picked Xerox on purpose because it's such an unusual one-off name, which means I wouldn't run into one of those odd things about Pacer, which is it really doesn't have an acronym library. It's not normalized, and I'll explain that in a few slides coming up. So once you go into Pacer for a year, and it's for Xerox, which you can see to the name just to the left of the blue ellipse, all I'm pointing out here is that some of these columns of data are live, and you can sort them. If you put in Xerox, you get all those subsidiaries, but business comes before corporation. You can sort on the courts. You can sort on the nature of suit codes. If you click there, for example, you get 190 probably first. You can see there are several 190s there. They are for breach of contract. And you can see a couple of 442s. Now you know that that's employment discrimination. If you clicked on date filed, it would sort from bottom to top, earliest, latest, or the reverse. Okay, so once you do that, you'll find out that, gee, Pacer isn't as expensive as you might think, because to do what I'm going to do now is costing only about 10 cents. All right, what nobody seems to work on to any great degree is this little thing up here called filter results. But boy, is that functional. When you go to filter results, first of all, you're going to see that a year has been called out. But then there are these other things that you can look at. And what I like to do first is go to party role and pick out DFT. You can see that sort of towards the bottom of that list there. DFT basically means the capacity of Xerox is not anything else other than defendant. So I wanted to see more about how many cases Xerox was getting. And if you go back one step or two steps, there were 86 records altogether, but if you just focus in on defendant, there's only 55. So now you know you're just looking at cases where Xerox is a defendant. There are 55 records, and you keep going with the filter results, and you find, okay, I've done this much. Now let's check nature of suit code. And when you do that, you see all of the nature of suit codes where Xerox has been a defendant, and they're in numerical order, and better than that, the frequency of these lawsuits against Xerox for that particular year go up. So there were 9 breach of contract cases, 440 and 442 and 445 are all under that civil rights rubric, 442 being employment. In other words,
Nick, can I interrupt you for a moment?
Yes.
I think some people still have problems hearing us or seeing the presentation. Is that happening to several people online? Can somebody let us know if you can actually hear us or
in the chat.
or you can see us, you can see the presentation?
I can hear and see.
Okay, so everything's okay. Let me see.
People need to check their local stuff.
Yeah, so I think it might be, Monica, it might be your local sound. Let's write this to Monica. Monica, local. Oh, why does this not work? Sound. That is sound. No.
on my screen it's very clear, but on what's...
No, it's clear. I got it.
Oh, okay, good.
Okay. Okay,
So there's someone else who is having a problem connecting. So.
Okay. Yeah. So my apologies for those problems. So it seems it works for most. So yeah, I apologize for that. All right, Nick. Please.
Okay, thank you. So right there, you see really what during the course of one particular year, what Xerox has to face, and what I realized was, gee, if you can do that, you can write it down pretty quickly, and you could even oh, sorry. On this particular slide, I'm just calling out the fact that I switched from Xerox here to Walmart, okay? So at the top of the screen, my little example here is if you pick Walmart and 442, then you'll get all the 442 cases for Walmart, but how many cases?
What? Okay, somebody, I think.
Okay, so how many cases would you actually get? You get 21 records. So that's the answer if you use Walmart. But if you use Wal-Mart, which many people use to describe Walmart, this is all up to the plaintiff when they write the lawsuit, because that's how it goes into Pacer, and they don't care, and they haven't regularized that Walmart without a dash is the same as Walmart with the dash. Now you've got 116 records. They're all 442. They're all for that same year. It's just, you have to be aware of that with respect to the name of the party, because Pacer can give you different results unless you're aware of it. So let's go on to how you find all these nature of suit codes in Pacer. It's easy. If you went back to that first page to start a search, in the lower right-hand corner, you'd see the search the site local search box, and if you put in NOS codes there, Pacer would take you to a place where they have a PDF, and if you click on that, you get the list. I just put in the very top of it. They're categorized by contract, but really the categories that matter for a deep learning exercise is the fact that each type of lawsuit has a name and a category and you can easily find out using Pacer how many lawsuits were filed last week, last month. You don't put in the party name, so you get them all. So that tells you how many examples you've got from everywhere in a particular category. Just some other functionalities briefly in Pacer. You can search by region. You can search by, and when you search by region and just scroll down, you can get into different circuits. And if you scroll down some more, you can get into district courts. So it depends on where you want to search. You can narrow it down by, I like being global about it, but I just wanted to flag that for you that you can do that. I had the question before. Now, this might all sound really basic, but here comes the exciting part. Let's add some money, because that's what this is really all about here. And there is a company called Towers Watson, New York Stock Exchange company. When the whole tort reform debate was raging in Congress, for 15 years, they got data from AM Best and from SNL Financial, and they tracked two things: commercial tort litigation and personal litigation. The personal litigation was more about automobile accidents. That was the predominant space for it. The commercial tort costs were all about whatever had to be paid. Don't forget, these are insurance companies providing the data. So it was the payouts for settlements and verdicts. It was the defense attorney's fees and the administrative costs. I took the last 10 years and I plotted it, and that's what it looks like. And the average turned out to be $160 billion. Now, if you
what does that represent? Sorry.
It represents the total cost per year of U.S. commercial tort costs, where costs means defense payouts for settlements and verdicts, defense attorney's fees, and administrative costs. All of that came from insurance data, which Towers Watson aggregated. Now, what Towers Watson did not do, and which I did in a book called Preventing Litigation, an early warning system to get big value out of big data, was to figure out the cost per case. And I took the first, 8 or 9 chapters to actually go to Pacer and to the National Center for State Courts, do the best I could to come up with just the commercial tort costs. Now in Pacer, most of these nature of suit codes are commercial tort lawsuits. Some of them are not. Some of them are like FOIA requests or prisoner petitions, habeas corpus, for example. Okay, I didn't count those. But for the other types of cases, I counted them, and I got state court data and did the best I could to aggregate them over that same 10-year period of time. So I wound up with about 3.909 million lawsuits over that 10-year period of time. And I wound up dividing $1.6 trillion, because that's $160 billion per year times 10 years, by 3.909 million lawsuits, federal and state. And that actual number turned out to be $408,000. So I backed off a little bit to $350,000 in order to have a $350,000 per case average. And that got me below 9 out of those 10 years. And I thought, okay, I'm at least being conservative about that. That's still not the wonderful thing. The wonderful thing is going to create a litigation risk profile. And so on the left-hand column, you can see 5 years worth of what I did with Xerox, again, just as a template. And across the top, you can see the nature of suit codes. There's a key on the left-hand, bottom left-hand of this spreadsheet. And so doing this, you can see a 5-year trend. If there's either a trend or there's not, or something new has popped up and you have to care about it. But those 6 nature of suit codes over those 5 years actually turned out to be 80% of the total number of federal case law cases for Xerox, and that turned out to be 190. So 152 divided by 190 was 80%. And then when you multiply the caseload by $350,000, you wind up with millions of dollars in litigation expense. This is just federal court, so it's just a snapshot. I took it against Xerox's published net profits. The 2014 annual report gave me the data going back for 5 years, and then it's a simple division to come up with what percentage of the net profits is the cost of litigation. I think this is useful stuff for corporate legal departments to use. I have no access whatsoever to all of their litigation data or what their average costs are for all of it, but that's at least a template of how to put it together so you can see trends over time using nature of suit codes, and then they would use not my average over 10 years, but whatever their actual average is, and then they can compare it to their net profits and you know, have a real good understanding of what litigation is costing them. So the payoff basically is to use their actual average cost per case. They would do it the same way A&M Best did it, with settlements and verdicts, defense fees, administrative costs, and then divide by the number of cases. And when they're using PACER, use advanced. The date range has that format. Use the party name and be aware of possible alternatives, because PACER is not. And then use filter to go to the capacity of defendant, use the nature of suit codes, build a spreadsheet, and see the case types over time and trends. And one reason you might want to do it is to adjust your insurance coverage. Different types, if you start seeing a trend for asbestos, for example, you might want more coverage for asbestos. Okay, that's the first part of my talk. I'm going to come out of this and start talking about deep learning.
Do you want to see if there's any questions on the first part?
Sure. Any questions? I don't know.
Does anyone have any questions at this point? You can, if you want us to hear you, you have to unmute yourself, or you can also use the chat function. Okay, has anyone built this methodology into a pricing strategy for legal services?
I'm not aware of anyone that's built it into a pricing strategy for legal services. What you're going to hear about me talk about is preventing litigation, being able to see the risk in internal company enterprise emails in particular, but not exclusively, and therefore provide a value for avoiding litigation.
Okay.
The first part of the book that I wrote had to do with what's the business case for preventing litigation. And I used PACER for that and came up with that average number and built that spreadsheet. So I hope that helps. But I realized what I did essentially is using such global data that it's really only going to have different meanings to different companies. Was there another question?
Okay. No, it doesn't seem like there's any other question. If anyone, no? Okay, so please go ahead.
Okay. So now I'm going to talk about the pain, but I can do this very quickly because you've already heard me talk about why that was $160 billion per year. It came from Towers Watson, not me. I did the cost per case, and so, you know, as you probably all know, when an enterprise settles or even wins, it still loses because even if you win the case, you've had all the attorney's fees associated with the strategy, the work, the e-discovery, the trial, whatever. And so an average might be $400,000 per case or $350,000. It's still such a big number that if you manage to avoid 3 lawsuits, you're leaving $1 million where it should be on the bottom line of net profit. Don't forget, the cost of litigation is not a cost of goods sold, and it's not a part of services rendered. It's coming out of net profit. And so the only winning move, and I got this line out of a 1983 movie called War Games, the only winning move is not to play. Well, nobody can actually do this now, I think, except us. And so there's the EDRM, and it all gets triggered when, there's a reasonable expectation of a lawsuit getting filed or somebody gets served. One of our colleagues at Introspection is Sean Doherty. Monica knows Sean very well. He was the technology editor for Law Technology News for quite a number of years. He edited all the articles I ever wrote for Law Technology News. And for example, Sean knows that when Watson was going to play Jeopardy, I wrote an article that predicted that Watson would win, and I think I was the only one to actually go out and say that, and then it happened. So he thinks enough of what I'm about to show you to know that, hey, there's a really valuable use case if you can be in front of litigation, when it's served and all the costs associated with e-discovery, not to mention the loss of productivity when you tell somebody who's a technology employee, please set aside your here's copy of your hard drive, set it aside, and don't worry at all about the fact that you're going to have to sit down with a company lawyer and then eventually get deposed by an outside lawyer who's after your scalp. Don't worry about it whatsoever. It's all part of the game. The lawyers are comfortable with it. They're not. And not to mention the fact that sometimes regulatory investigations can go south, and if that happens, then you're looking at a criminal case, and there's and then the government has to prove a specific intent to do harm. But if you've got a system like this on board, you can actually provide them with evidence of a specific intent to avoid harm, just the opposite. So we're in front of all of that if, in fact, it works. So I'm going to show you it works. There is a wrong way to play, however. If you're working for a company, you're part of the legal department, and you want to do what you think is best for the company to drive down the frequency of litigation. And one wrong way to play that game is to create a word rug, which I'm in the current parlance, I'm calling those word rugs alternative facts. And the example, and it's really a horrible example to have to give, but it's a real example. During the ignition switch case, because they had no insight to actually surface these risks, they tried to train the product engineers, the safety engineers, that they should never say the word defect. They should say does not meet specifications. That. They wrote that up, and they produced a PowerPoint, which they then gave to these various people and said, here are some examples of words or phrases that are to be avoided.
So that's the legal department instructing their product people?
Yes.
Okay.
And the words were things like, don't say, and it's a long list. I've highlighted some of them. Don't say Challenger blew up. Don't say Cobain, he committed suicide. Corvair was a car that blew up. Don't say debilitating, decapitating, disemboweling, eviscerated. They came up with all these words. Don't say Hindenburg, it blew up. Don't say Kevorkian-esque, he was Dr. Death.
Titanic.
There's Titanic. There's rolling sarcophagus. Don't say your toast. And believe it or not, that got written up as a Wall Street Journal blog article on that date, May 17th of 2014, and it was called the 69 words you can't use at GM. So that's what Tom Gara did also was post the consent decree with NHTSA that GM had to enter into, and of course it covered a couple of things you had to look for. What I'm about to tell you. The consent decree covered recalls, and it covered fines. I think it was $30 million or $60 million. It wasn't a small number. But they also had to disavow this teaching. They had to go back and say, some lawyers did this. It's really not a good idea. We should really be getting the truth from you instead of a word rug like this. So we disavow this previous teaching. And I believe 4 lawyers got fired. That's not the right way to do it.
How did the lawyers come up with that list? Is this a sort of a reflection of what e-discovery systems are typically looking for?
I have no idea how they came up with that list. But since they were not talking to control group executives, they were talking to, safety engineers and design engineers, the attorney-client privilege did not apply. So NHTSA found it. NHTSA found this PowerPoint, and they put it into their consent decree. And that's how Tom Gara found it and made a reference to it in his blog article. That's how I found it. The title of the darn blog article was "The 69 Words You Can't Use at GM." So how the lawyers came up with it, I have no idea. So deep learning is different. Here at Stanford, you've got some real stars. Andrew Ng was quoted in Fortune magazine as saying deep learning is the new electricity. By new electricity, he meant that electricity changed every industry during the Industrial Revolution, and that deep learning, in his opinion, was going to change every industry now. It's really moved forward.
Is it about deep learning or about AI in general?
Deep learning. Quote, deep learning is the new electricity, unquote. And if you go to that Fortune magazine article and put in, quote, deep space learning, unquote, to get both words together, and so it's not just deep and learning, and maybe you get learning, or maybe you get deep, quote, deep learning space, sorry, quote, deep space learning, unquote. You put that in a local search box for Fortune or Forbes now, there is a giant amount of conversation about this and how it's going to change lots of things. And you can read the list, but all of these companies are spending multiple millions, if not billions, doing this. When Google saw a company called DeepMind doing this with just Atari games and beating Atari games, all of them, 47 of them, overnight, just by having the deep learning look only at the pixels with the instruction of getting the highest possible score, the algorithm didn't do very well with the first 100 games and looked like it was making some progress after 300 games. But after overnight running 500-600 games, it was perfect, not only for Space Invaders or Blockade, but for all the other companies, for all the other games. And Google realized that they had assembled a team of 100 deep learning experts in London, and this was their sort of proof of concept, and bought the company for about $650 million. Now, Salesforce is on this list, in particular because you have another Stanford star. Richard Socher got his PhD here in computer science in 2014. At the very end of 2014, he got $8 million from Vinod Khosla and Mark Benioff, the founder of Salesforce. And so he put up a company called MetaMind. MetaMind had an OpenAI. I was pretty much working with Bill Inman's technology, which is sort of the middle 5 chapters of my book, and sort of realized during the editing process that deep learning was something that needed to be called out and investigated. And there's like on page 169 or 170, I actually mentioned it and said, here's what's going on. A lot of money is going into deep learning. I know enough about previous investigations and Watergate, follow the money. Okay, got to mention this. I didn't really know too much about it. The book came out in August of 2015. Believe me, it's not a bestseller. But I learned that I needed to go up the curve on deep learning. Now, so I got in touch with Richard Socher. He said, you need labeled data and examples and lots of it. So he had an open API, but a black box algorithm. So I used Pacer. I did what I just showed you in the first group of slides. I pulled off examples from employment discrimination and said, okay, that's the label, employment discrimination. Here's some examples. And it went into his algorithm. And then, okay, fine, I now have a trained model. What was it going to work on? It was going to work on it was going to work on emails. Well, the only available block of emails publicly are good old Enron emails from 2000, 2001. But when Enron failed, the government made all those emails public, and it's a giant set of something like 600,000. I cared about risk and prevention because when I was at law school at USC, Lou Brown was one of the professors, and he is known as the father of preventive law. And that stayed with me for something like 40 years, and he passed away in 1996. So he never saw the computer advances that have been made now, and I managed to live long enough to see it, remember what he was talking about, and try to figure out how you could have a trained model from some external source, not including emails, trained onto or look at enterprise emails for risk. Now, deep learning is dealing with risk. Here are all the companies involved with making self-driving cars, and they are all engaged in risky behavior because they're going down the road. They could veer outside of the lanes, they could go too fast, they could see something up front on the right that looks like yellow but small. Now, is it a 6-year-old kid wearing a yellow rain jacket, or is it a fire hydrant? One of the two is going to jump out in the middle of the street potentially. So, do we have enough examples of one or the other so the algorithm can either grab hold of the steering wheel or tap the brakes, and it can do that faster than a human being's reaction time. So they're all interested now in self-driving cars. I think of self-driving cars as a way to deal with risk. Different kind of risk. It's much more like DeepMind and looking at pixels on the screen. I was a lawyer for 38 years. I did litigation. I swim in words. So I don't use a convolutional neural network. We used a recurrent neural network. Now, the problem with using a neural network with Richard Socher's MetaMind is that Salesforce bought the company for $39 million in March of 2016 and closed down by April. So that was a problem. Fortunately, I got a referral to Indico Data Systems. They're a platform with a deep learning algorithm, probably more than one. And I got referred there and tried giving them the same training data and the same test data and got basically the same results from another company. And then I realized, this might not be so great. Their CEO was up for it, but their VC people and were putting up roadblocks. So I realized, I better find open source. And just about that time, Google came out with TensorFlow. And so there are now probably about 5 or 6 different platforms for deep learning systems. And that turned out to work. So then along the way, and I'm trying to go through from a chronological point of view, in late June, and the lawyers listening in will all know Alice versus CLS Bank, the United States Supreme Court in 2014, basically said, software system patents, good luck. You're not going to get them. You're just using a computer to do what a human being could ordinarily do, so there's really nothing new here. And for that reason, the United States Patent Office started turning down software system patents. But then after a case called Enfish versus Microsoft, I saw on June 27th a case come out called Bascom Global versus AT&T Mobility. And there, in the Federal Circuit, they said, look, if you've got an inventive concept, and even if you use generic claims but use them in a unique way, that's okay. You can get a patent for that. That was kind of and the patent in that case was allowed, not turned down, and it was a software system patent, notwithstanding Alice versus CLS Bank. So by July 1st, 4 days later, I had a provisional filed because basically the system was already in my head. I just needed to write it up. I didn't write up the claims. I'm not a patent attorney. I was helping, before I retired, I was helping a patent attorney in Pasadena, California, with his litigation, patent litigation. Okay, fine. Litigation, I can do that. So I learned something about patents, and I wrote the specification. Once he was on board, so the provisional was filed on July 1st. The application itself was, nobody reads provisionals. It's just for holding a date. You've got priority in case somebody else has got your same invention. The application is supposed to get read by an examiner one day, and usually it takes 4 or 5 years. We filed our application on September 27th, 2016. The surprise was the notice of allowance came out on December 12th of 2016. And the patent was allowed, and there's the number, on January 24th of this year, just shy of 4 months. It went to the, I've got the whole file wrapper, it went to the artificial intelligence unit, whoever it was that did the work, did their own research. The file wrapper shows that whatever I tried to suggest might be disqualifying. He did his own work and came up with whatever he came up with, and there were no office actions, there were no amendments requested. The 3 independent claims were allowed, the 17 dependent claims were allowed, and so there's a patent for, and here's the title of it, Using Classified Text and Deep Learning Algorithms to Identify Risk and Provide Early Warning. So now I've got a good case for a business because not only is there a high value to it, it's patent protected. Okay, what is it? Well, I've already told you that deep learning learns by example. It's a neural network. And let me just say briefly, there's this giant overarching term, artificial intelligence. A subset of that is machine learning. A subset of that is neural networks. And a subset of that are these deep, multi-layered neural networks. So that's what deep learning is. It learns by example. Google realized it had all this data from when they created Street View and had cars driving down the road. Well, okay, have the algorithm pull all that in and understand what was going on. Then, of course, they put cars out on the road, and they're learning from all the examples of whatever the cameras and LiDAR and connections back to the steering wheel and the brakes, all that is being learned, and it's learning by example, and it's not very different from what babies do when they first turn over, then they crawl, then they walk, then they run, and we do all of these things by example and trial and error, and we get better and better at it. So we picked what Richard Socher told me to go pick was a label. Okay, that's a case type. That sent me back into Nature of Soup codes. I picked one for a first case, and that was previous lawsuits. And what that means is, in this invention, this is different from every other kind of search methodology people are exposed to. There are no keywords, no lists, no expert rules, no ontologies, no taxonomies, no concept search like the ones that content analyst or which uses latent semantic indexing. That's what LSI stands for. Recomind is based on probabilistic latent semantic indexing, not that. Nothing called predictive coding. None of that is involved. And the wonderful thing is there's no programming for a user to do. That's all done by us when we train the algorithm for the different use types. And now you know something about Pacer, and there's 160 Nature of Soup codes altogether, and not all of them are business relevant. I gave you some examples before. So we trained our system with examples, and here's the best way I found to try to convey what the system, quote, understands, unquote. That's a target, and there are a bunch of arrows, in the center. That's not because the arrows are meant to convey that someone was a good shot. Someone stuck those arrows in dead center, and now the algorithm understands what you mean by dead center. So those are the complaints in employment discrimination cases where, and I know this is heresy, I don't care about the law. I don't care about the legalese. I completely pass by as noise the jurisdiction and venue section, the parties, the claims, or the prayer. I care about the factual allegations because those are the examples of employment discrimination. And after you pull together enough of them, you've basically told that target what you're looking for when you look at something else like lots of darts.
So you just looked into the facts of the cases.
That's all I care about.
And had your machine learning algorithm, deep learning algorithm, trying to kind of digest the facts, and that's what you're going to use for your predictive model. Okay.
That's pretty close, right? And we do this in an automated way so that when I want to train a different model for, let's say, breach of contract, I can specify that date range for date of cases filed. It doesn't have to be a whole year. I mean, if I wanted employment discrimination, in any 1 year, there's like 12,000 minimum. The highlight was around, the high watermark for employment discrimination was around 2000, 2001, when there were 20,000 cases every year. It's actually gone down. There's been less employment discrimination. But in terms of examples to upload into an algorithm to process, and Richard Socher was involved in this too. Google came up with something called a word embedding using a sliding window. And I don't want to get too much in the weeds on this, but basically you can take a string of words, put them in a window, and then get a vector out of that, and then move the window by one word, and move the window by one more word. And every word gets context associated with it, because the word Ford may have the word president in front of it, or it may have the word motor after it. And once you start seeing words that way, and they're getting turned into number strings, that can be ingested into an algorithm. It's now capable of processing numbers, and that's basically how the algorithm can learn and understand with examples what you mean by the bullseye or what you mean by discrimination.
We have about 13 more minutes. I want to make sure that we leave some time for people to ask questions too.
Okay, I'll zip through it. Well, so now you know that there are different codes, different categories, and you know, in practice, you could think of each of these targets as a filter. So you can have a multiplicity of filters. One of them is going to be trained with breach of contract factual allegations. Another one's going to be trained with employment discrimination. Another one's going to be trained with antitrust. And basically you're saying, okay, I want to see all the emails from yesterday, and we're going to batch process them overnight, and all of those emails from overnight are going to go through each filter.
How much?
So
how many of those facts that you're picking up are actually making explicit reference to email communication, or is that sort of a layer?
We're just copying emails. I mean, what we are doing with company emails is just copying them, indexing them so we can find the original ones. I'm going to get there in just a minute.
Yeah.
Okay. But you can do this with any text. So it could be a text message, it could be a call center note. Doesn't matter.
Thinking about the cases that you pick up on Pacer.
Okay.
Just looking at the facts. The facts in those employment cases making explicit reference to words that were used in email communication.
No. The factual allegations are, I was at work, this is what happened to me, this is why I came to see the lawyer, and it's up to the lawyer to write a claim. So it's, and all of this word embedding that goes on isn't word by word or sentence by sentence or paragraph by paragraph. It's that whole block of text. That's one document.
So what I'm trying to get at is that you still need sort of a layer of translation, and basically to say, like, if those facts in those employment litigation cases are present, then, and you're looking on the other hand as your
the enterprise emails.
The output data that you're looking for is basically what kind of words that are used in email communications might ultimately be a trigger or set a company on a path towards an employment litigation. Is that
okay?
You lost me.
You're sort of describing a word-based search, and it's not that. The algorithm will look at emails and say, you know, does that match up to the bullseye that I know about? Most of them don't. I'll show you this in just a second.
Okay.
The whole idea is to monitor enterprise emails. That's the internal data. The external data is the training data. This is the test data. We want to find the risky emails, risky needles in the haystack. So now, what about the UI? What would you actually see if you were an attorney working for a company? You would see on the left-hand side that we processed about 5,000 emails and found that most of them, 99.5%, were unrelated to a discrimination risk. But in terms of accuracy scores, here's a little spreadsheet where 1, 2, 3, or 4 emails scored high, and the highest scoring emails are off there to the right. That's why they're circled. That's just for context. We're only going to give you 2 screens to look at. And the second screen basically has more of the functionality. But what surprised the hell out of us was that when we tried this on Ken Lay's email subset, he was the chairman and CEO of Enron. We didn't expect to see an employment discrimination risk there, but on the ellipse on the left, the lower one, it says my unfair treatment at Enron, please help. And then I sort of made a bigger deal out of the one on the right because it says my employment with Enron is to be terminated. In other words, there's no job action yet. It hasn't happened yet. There are no damages yet. There's no lawsuit yet. Great. I don't know why it's in Ken Lay's emails. I think we were the first to ever surface it, but there it is. And what the whole point of this is to augment the intelligence of the attorney who gets this early warning. Now, there in the upper left-hand corner, I know it's hard to see, but we have a functionality for open email. We index all of the emails that we take into the system to look at. And that means that we can find that email. And when we say open email, that means we can get right back to the email right out of, so that's a PST file, and that's the actual email. And then you can, here's the other tab on the far right. I'll just show you the difference. That's on the left, upper right-hand corner, here's the right. The whole idea is to have the attorney read this and say, okay, here's one that's worth investigating. The algorithm says it's matching up really well. In fact, this one, hit 0.98, where 1 is the maximum. So in other words, this is a true positive. And from there, we would kind of stop and say, okay, export this out to your existing case management or investigation system. We're not going to reinvent that wheel. So take a look, and once you get there, you can do the email threading, or you could go to HR and go and seek performance reviews. And the whole idea is to build a little bit of a discussion or a case to present to a control group executive. Now, I'll get a little bit of technical, but I'll try not to be too much about it.
You have 5 more minutes, by the way. If you want to leave time for people to ask questions.
I'll skip the technical.
Have comments actually also. Let me just see what. Seems you could use this tool to find your own clients too. Litigation cost versus earning ratio. Target for this latent exposure detection machine.
I don't understand the question.
Yeah, I'm not sure I understand it either.
Okay, so
maybe
I've got a few more slides. Let me just zip through them.
Go ahead, please.
Right. So when you're building a model, what you care about is, hey, there's a whole lot that's not related to discrimination, and if you see, if you're using only 10 layers, 10 nodes is what they're called, then some of the true positives might get mixed in, and you don't really have a clear decision boundary. But if you use 50 nodes, then you've got a clear decision boundary, and that's why we knew our model was good. We knew our model was good also because Indico gave us something called a receiver operating characteristic area under the curve result, 0.967 out of a maximum of 1. That was pretty good. After we switched to TensorFlow, where again the maximum is 1, we got 0.998, which means we could process 1 million emails and still come up with only a few hundred for the legal team to look at as potential risks. So to sum up, when the system is installed by the legal department, sorry, this is not for law firms, this is for the client. This is for the benefit of the client. Less litigation is a good thing, and there are policies in place so that employees know that when they're using company computer resources, there's no reasonable expectation of privacy. The attorneys get an early warning of the risks, and now they become Sherlock Holmes and they do some internal investigation, and then they can advise their client. And so we've made use in the workflow of the work product doctrine and the attorney-client privilege. And so the bottom line is this system is capable of heading litigation off at the pass. The whole idea is to nip it in the bud. And I hope that big message gets across, because the attorneys who are closest to the risky data are the company lawyers, but they are blind to these risks and they have to just deal with the law. So now here's a new power. It's an advance, I think, for the whole profession. So they don't have to manage lawsuits, they can avoid them. And that's the end of my talk. And we're happy to do a demo with companies that are interested. We have our first, I gave my first talk on this last Tuesday, 2 days ago, at the Association of Corporate Counsel Legal Apps. This is my second talk, and we have our first pilot project underway now with a New York Stock Exchange company, and I can't tell you the name.
That's great. That sounds great.
That's the whole thing. Prevention. Oh, there's one more thing for me to say. Some very famous people in the legal space, Jason Barron, Ralph Losey, and Mike Berman, came out with a book at the end of December last year called Perspectives on Predictive Coding. The last chapter was called Preparing for the Near Future, Deep Learning and the Law. Now, they didn't talk about what I just talked about, but that's not the near future anymore. The near future is here.
Great. Thank you very much, Nick. So somebody's asking, you could use a similar mechanism to find companies who are spending disproportionately large amounts on litigation costs versus earnings, and use it as a kind of
exposure detection
dowsing rod for finding the companies who could use this service the most. You need to scrape earnings reports of Fortune 1000 first.
Except that I don't have access to any of that internal corporate data. You can take and I did this in my book, you can take the Fortune 100 and turn that into the litigation 100. Because you take each company and you find out exactly how much in the way of litigation they've gotten, just by the number of cases, federal only, but in PACER. You put all these 100 company names in, and you do what I did in the first part of my talk. And you can re-rank, I did it in my book, you can re-rank the Fortune 100 into the litigation 100.
Yeah, that's very interesting. Which one's the leading, most litigating company?
Walmart.
Walmart is, okay. And what kinds of cases like?
By far. Employment
cases.
Yep.
Okay.
Labor Standards Act, discrimination.
Which one?
They have so many employees. I mean, just by virtue of that.
And what's the next one? I have to buy the book. I'll buy the book.
I have to look in my book.
Yeah, no, that's right. Do people have any other questions? Okay, so MW is writing. Thanks very much, Nick. I'll follow up with a question in email which will focus on your expertise broadly in terms of legal informatics. Okay,
and so my email wasn't really on the first set of slides, but there it is in front of you. It's nick.brestoff@introspection.com. Oh, and there's one other thing. After if you do look at the demo page, there's a 5-minute Vimeo there that sort of takes you through some of this now that you've got all this background. But just below that is a TED Talk by Jeremy Howard, where he explains the wonderful and terrifying implications of computers that can learn. And by the way, this is also in Skype, where they can do real-time translations between English and just about 40 or 60 or 80 other languages also using deep learning. It's like Andrew Ng said, it's going to change everything. Here I am with legal.
Great. So any other questions? Anyone have any additional questions? If you want us to hear you, you have to unmute yourself. All right. Well then, thank you, Nick, for joining us. Doesn't seem like there are any additional questions. So I would be actually curious to just understand the use case just a little bit more. So this is a technology that will be used by law firm lawyers that will use it to counsel their clients? Is it used as a automated kind of screening tool that corporations will use to kind of set up alerts, to send out alerts when certain things are happening in their email?
The alerts would go to lawyers. They're the only ones that would be privileged to get the early warnings. The problem with law firms is that less litigation is a little antithetical to their business model.
Yeah.
Number one. Number two, there's a conflict of interest. And I had this discussion with Bennett Borden once. The transactional lawyers might think they would be getting great loyalty from their clients, or even attract new clients that they don't have currently. Great. Transactional lawyers are happy to give their clients a way to see the risks before they have to manage the lawsuit. However, if that were to happen, the litigation partners, I can just hear and envision the next meeting where they say, well, great for the firm, happy that the firm is making more money by having new clients, and fine, but you cut my throat to get there.
Yeah.
So that's a conflict of interest, and that's why I can't see any law firm actually doing this unless they're very unusual.
So at this point, you have a patent, you have a company. Do you have like a business model already? I mean, how is this going to be?
Yes. A company called Mitratech came out with a study last year, 2016, early, that said, we've done a survey. There are 10,000 companies large enough to have legal departments. 31% have between 1 and 9. 59% have between 10 and 39, and there are 10% with 40 or more.
Okay.
40 or more out of 10,000. 10% out of 10,000 is 1,000. Given the pricing that we're envisioning, I'm happy with moderate and high, a large corporate. I don't know that the smaller law firms would be all that interested. Maybe not. But we do have pricing associated with this, and it's not like we've locked it down.
Okay.
We are at the stage of going to market.
Got it.
And that's why we have a contract for our first pilot project, where instead of Enron, they're going to use emails from now closed employment discrimination cases where they know what the risky or smoking gun emails are. I'm not going to see it. We're going to give them computers. They're going to load their emails in, and they'll see whether or not we surface what they already know to be risky or smoking gun emails. And if they learn from their own data, they'll hire us.
Cool. Well, that sounds like a good project.
There's a couple more chats.
Okay, you want to read them?
Anyone in litigation funding sniffing around, says RN.
Oh, no. If I understand litigation funding, it's like funding plaintiff lawsuits?
No, you could, I think there are people
Financing,
there's hedge funds financing lawsuits, or you could even buy shares now in lawsuits, and
models.
you could use that information potentially.
Okay, so I don't...
At either plaintiff side or defendant side?
I don't want you to miss the point. This is for corporate defendants to avoid lawsuits. This is that much of a shift in the paradigm. How do you do that? I tried lots of different ways to do that. Deep learning finally worked.
Okay.
And the other one is an alert covered by attorney privilege?
Yes, because the system is onboarded by the legal department, so it's work product, the list of the alerts go out only to a privileged list created by the company, which consists of lawyers or paralegals in the legal department who are entitled to get the alert.
Mm-hmm.
So then they can, they now have a window in on all the emails from yesterday, and they can see which ones are risky enough to justify an investigation, and then they can do that, and that's work product. And when they advise a control group executive, don't make the mistake that GM made, then it's attorney-client privilege. So yes, it would be the alert is intended to be covered by the attorney-client, by the work product doctrine.
Okay. All right, we're already 6 minutes over time, so thank you so much again, Nick, for coming in. It's very cool. Please keep us updated, and all the best for your venture.
Thank you very much.
All right, thank you. All right, and we'll be meeting again in sometime in August, I guess.
Sometime in August. We'll have Zoom rather than Blue Jeans, so this is University IT, and we'll be in a new room here in Newcomb, so stay glued to your email. Everything will be new in the next academic year. This basically concludes, this is the last session this academic year. Mm-hmm. And thank you, Nick, again, and I think we had a great year with a lot of great talks, many of which we have videotaped, and you can find on our YouTube CodeX channel. And we'll see you again at the next meeting. All right, thank you all. Bye.